Bill Ainsworth, Nueces County District Attorney's Office. With the limited time remaining, I wanted to talk briefly. Ms. Norman said that the ineffective assistance claims dovetail in some way. I think Ms. Orr said that too, with the issues involving the Brady claims, and to the extent that they do, I'm not trying to harp on that over again. This court, y'all remanded the case back, and there were really 3 issues to look at that y'all said on these ineffective claims. I think 2 of them weren't really addressed by defense counsel, and so I won't spend, or petitioner's counsel, I won't spend time on that to any great extent. But this miscommunication issue, I don't think that the testimony that was developed at this red hearing showed any miscommunication. That they were, they might have all been on one page every single step of the way, but that there were 7 or 8 lawyers, of which at least 3 or 4 were expert criminal lawyers, and John Gilmore is an attorney who's been practicing for many, many years in criminal law of all kinds, including murder cases. The lesser included offense issue, again, I don't think is something to take up a lot of time with, because I don't think that's something that was...
Mr. Ainsworth, could you address the
yes,
failure to call expert witnesses concerning PICA and the treating physician who was aware that he had all these problems before this event?
I think
the defense counsel may all be individually great, but this sounds like a classic example of too many cooks in the kitchen and they didn't know what was going on.
this is the issue of Dr. Moritz and his testimony, and they did call an expert, by the way. Dr. Melinek is a medical examiner from San Francisco who did testify and talked about issues involving forced ingestion and that sort of thing. So they did have an expert testify, but as to Dr. Moritz and his testimony, Dr. Moritz went back and they did this deposition, which is unusual during a criminal trial, to have a deposition in the middle of the trial, but they did this deposition, and all you heard was David Jones testified, and Mr. Jones said, I wasn't there at the whole, when we made the decision about whether or not to use that video, but Chris Pinedo testified, I was there, and I decided that it wasn't a good idea to use that, and that's why we advised Mr. Gilmore, who was present during the trial, and so he wasn't there for the deposition, that wouldn't be useful. And the reason why it's not useful is the same reason why it's not a Brady issue, is this issue with Dr. Moritz, the things that he could testify to, they don't really contradict what the state's claim was. Again, there are these 2 issues. It could have been forced ingestion, or it could have been an issue involving neglect. This lady who's an LVN and EMT certified, that she didn't take the child to the hospital. But neither one of those is contradicted in any way by what Dr. Moritz said, which is that salt ingestion caused the death of Mr. Bird, or the death of Angie Bird. I think that's clear from all the testimony from everyone who spoke. And Dr. Moritz, even in the writ hearing when he did testify, didn't contraindicate that in any way. And in fact, had he testified during the trial, there's all sorts of things that might have opened the door to, and I think that's why they chose not to put him on in the first place.
Did the judge of the convicting court make fact findings?
He did make factual findings.
Are you going to ask us, and I'll have the same question for you, are you going to ask us to unfind or disagree with any of those findings?
No, Your Honor, we're not. The factual findings of the trial court, I think, speak for themselves, and the trial court made factual findings saying that the testimony of Dr. Moritz was unpersuasive, given the testimony of Dr. Fernandez, who was a medical examiner. What Dr. Fernandez said is that this issue, again, this dovetails, but this issue of Dr. Moritz and him saying, oh, well, this issue with the lavage or the Bemis canister and why that would have been important, Dr. Fernandez said that what is in your stomach doesn't tell you anything about what killed you. That's the stuff that didn't kill you, right? That's the stuff that they got out of him. It was the stuff that was in his body, and none of that tells you about who put that in there. And nothing Dr. Moritz could have said would tell you whether it was Andrew himself or it was Hannah Overton that administered that salt.
Did the jury know about Andrew's whole history of eating behavior, eating strange things and hoarding food, and the testimony from his treating pediatrician about his peculiar behavior and the whole concept of pica, the disease?
They were
may
given,
not be familiar to jurors.
They were given that testimony through the defendant herself, who indicated that this was his history. These were the things that he was doing. This is what was going on with Andrew, is that he was eating all these things, and that was contraindicated by testimony the state put on, saying that his previous foster parent hadn't seen any of those things, that there was nothing about that was indicated to her about pica or anything else, that he seemed like he was a normal child who was eating normally, and he behaved normally, that, you know, if there had been some sort of developmental, he was, you know, slow for his age or whatever, but in terms of this eating behavior, that was an uncontradicted testimony. There was testimony on both sides.
Counsel, I didn't remember that his treating physician said that he had these kinds of issues. Was it his treating physician?
No, that's not what his treating physician said at all.
Okay.
His treating physician, Dr. Rhoda, who testified, said that wasn't his opinion at all.
And what about his physician? Was Dr. Fernandez his pediatrician?
His pediatrician, Dr. Cortez, who did not testify, but was made available to the defense. Dr. Cortez, nobody was going to say, to my knowledge, that they knew as a physician that he had these issues. The only thing that they were given showing that he had these issues or pica or anything else was information coming from the defendant herself,
Okay,
who was giving them that
there's
information.
something in this defense brief that talks about Andrew being mentally retarded. Was there evidence that was he mentally retarded?
I don't have that evidence. I don't think that that's true. I think that there was some evidence given that he was, I believe there was some sort of Hawaii test that indicated that he is, was 8 months delayed, or he was slower than some of his peers, but that didn't mean the same thing.
I don't want to take up too much of your time. How long did the Overtons have him?
How long did they have
Was it
him?
4 months?
It was a short period of time.
How long did the Sharon Hamill, his foster mother, have him before that?
I believe that she had him for a similar period of time. I think it was a little longer than the Overtons had had him.
It wasn't 18 months?
I don't do you have an answer?
Okay.
I don't know, Your Honor.
Okay.
I believe it was longer than the Overtons had, but I don't know exactly.
When you say treating physician, are you talking about the one who treated him during the last medical procedure?
The one who treated him was during those procedures was Dr. Rhoda, who did testify. And Dr. Rhoda had testified that he didn't. I'm sorry, Your
I
Honor.
mean, if you're treating physician and you're trying to save a life, how much history do you go into?
And I think I may have misled him accidentally. I meant Dr. Cortez, who did not testify, who was his regular pediatrician when he wasn't having an emergency.
That's right.
Who had his history, his medical history. So that would have been the person that I was concerned
I
about.
doubt that he would be asking about pica and other things when he's trying to save a
What
life.
did Dr. Cortez say about his medical history? Did he have any indication that the child had soft pica, or did he testify about any of that?
No, there was no. Well, Dr. Cortez did testify.
He didn't testify, but did
He was available
testify
outside.
direct? Okay.
He testified, and what his testimony was in the motion for a new trial. He didn't testify in this writ hearing either. In the motion for a new trial, he was talking about his opinions about whether or not she committed the act purposefully or not, which wasn't really based on medical expertise at all.
Actually, that's my one question that I had was, co-counsel had said that the jury convicted her of omission rather than commission, and I wanted to know, was it a special verdict form that it was omission? Why do you make that statement?
It was, the process was improper, Your Honor. What happened was the jury was given both theories, and they came back with a guilty verdict. And after that, the defense counsel, Mr. Gilmore, asked the trial judge to poll the jury to ask them whether or not they believed it to be by commission or omission. And so in open court, each juror said omission. But again, that's not something that I don't think has a way to, that's not credible testimony, in other words.
But just having at the trial, the jury gives the verdict,
Yes.
then the jury's polled, and then the jury answers. That's
Right.
what I was trying to.
Right, then, yes, sir. Thank you, Your Honor.
Thank you, Judge.